22-186-783, J.P. Morgan Chase Bank versus Marcus Campbell. Date and time for pretrial appearances.
Good morning again, Your Honor. Jim McCardle on behalf of J.P. Morgan Chase, P numbers 82443.
And your name, sir?
I'm named for the record is I'm the authorized representative here on special appearance, the director and the beneficiary of the legal name of Marcus Campbell.
Are you Marcus Campbell or not?
I am.
All right. Where are we on this file, gentlemen?
Well, Your Honor, I filed a motion for summary disposition. I received a notice from the court saying that this was a final settlement conference, but I was hoping that the court was going to take up my motion for summary disposition. I've not received an answer or any kind of a responsive pleading to my motion for summary disposition. There have been numerous filings by the defendant, virtually none of which I understand.
The case is underway, and today's courtroom spectacle features none other than Marcus Campbell, the self-proclaimed sovereign citizen who's once again crashing headfirst into legal reality. From the start, Marcus refuses to acknowledge his own name, instead insisting he's merely the authorized representative of Marcus Campbell. It's courtroom cosplay at its finest, and the judge isn't buying a ticket.
Status of the cases.
Mr. Campbell, did you receive his motion for summary disposition?
I have sent a brief. I sent a brief to the courts.
Sir, are you listening to me?
Did you hear what I just said?
No.
I just said I answered. I sent a brief.
I asked you if you received his motion for summary disposition.
Yes, I have.
Okay. So then I'll just calendar it. That's all. Is there anything else outstanding?
Not that I'm aware, Your Honor.
Anything else outstanding, Mr. Campbell?
Yes, I do have something. I did respond to the courts and to the complainant.
Okay.
But before this matter go any further, I would expect 21 days and a provided proof of claim of evidence of the legal and lawful authority of this.
The court considers Jude Morgan's application for summary disposition, and the supporting documentation includes a demand letter that was sent, a lawsuit that was correctly filed, service that was finished, and a response from Marcus that was full of unclear and unrelated points. The most illuminating passage in his own records, Marcus essentially acknowledges that he owes the money. It's like presenting your own defeat from the beginning. The judge cuts through the commotion and renders a decision in favor of J.P. Morgan, marking the courtroom defeat number 1. Marcus arrived with flimsy arguments and irrational theories.
Mr. McCardle's motion for summary disposition, that if you say you filed an answer to it, we'll be prepared to go forward then. The motion for summary disposition, gentlemen, will be heard April 10 at 11 o'clock. We are going to call file number 22-186-783, J.P. Morgan Chase versus Marcus Campbell, date and time for a motion for summary disposition. Could I have your appearances?
Of course, Your Honor. Jim McCardle appearing on behalf of J.P. Morgan Chase.
Bar number?
82443.
And your name, sir?
Marcus Campbell in special appearance.
Mr. McCardle, this is your motion.
Yes, Your Honor. Your Honor, we had issued demand to the defendant on March 15th of 2022. Receiving no answer, we then filed suit against the defendant on May 13th of 2022. Proof of service was finally obtained on September 26th of 2022. The answer was filed on November 14th of 22, and then we subsequently filed our...
As the portfolio recovery associates begin round 2, Marcus uses the same tired strategies once more, mentioning a special appearance and appearing uncertain as to whether he has even seen the motion. The judge attempts to get a clear response, but it feels like trying to reason with a broken compass. Once more, the court is patient with Marcus's so-called brief and memorandum of law, which has no actual legal basis, but the firm decides to accept it as a legitimate response in order to proceed with the lawsuit. This judge isn't cooperating with Marcus's courtroom shenanigans.
Filed, the last of which is response to plaintiff's counter-defendant's motion to strike, in which the defendant has a number of things, but the chief among them in paragraphs 5 and 6, the defendant agrees with our motion, the allegations in our motion, that he's in default, and that there's currently due and owing a balance of $18,610.79. And then he in paragraph 8 in our motion says defendant's answer fails to refute the obligation of the plaintiff. The response is defendant counter plaintiff agrees. However, defendant counter plaintiff's pleadings are not redundant, immaterial, impertinent, scandalous, or indecent in manner. So I'm not sure what that's supposed to mean. The upshot of this is, Judge. Oh, there's one other thing. Yeah, he suggests in his paragraph 1E that my client is practicing law without a license. Well, we're here on behalf of our client, so my client corporation is not acting without an attorney, so that's irrelevant. So basically, what I'm asking for is judgment in the amount of $18,610.79. In essence, because
The hearing starts in the portfolio recovery, where everything is ready and presented. Marcus had been using the credit card to make payments for years without ever complaining. And now he's attempting to claim that nothing of the sort ever happened.
Stand on your pleadings. Okay.
Which was,
All right, the court's prepared to move forward in this matter. This is a motion for summary disposition filed on behalf of plaintiff and notice for hearing today. Plaintiff's motion for summary disposition was filed on December 15th, 2022. Following that date, the court's register of action does not appear that any pleadings were filed by the defendant. Michigan Court Rule 2.116G4 is relevant here. A motion under sub-rule C10 must specifically identify the issues as to which a moving party believes there is no genuine issue as to any material fact. When a motion under sub-rule C10 is made and supported as provided in this rule, an adverse party may not rest upon the mere allegations or denials of his pleadings, but must, by affidavits or otherwise provided in this rule, set forth specific facts showing that there is a genuine issue for trial. If the adverse party does not so respond, judgment, if appropriate, shall be entered against him or her. No response was filed to the plaintiff's motion for summary disposition. However, in his earlier pleading, which is really not relevant because they were not, again, filed in response here, the defendant admitted that he owed the money. So that's going to be it. Court finds there's no genuine issue of material fact. Plaintiff is entitled to summary disposition as prayed for under MCR 2.116C10. Mr. Campbell, you have an absolute right to appeal my decision. That appeal must be.
When Marcus enters the Zoom hearing for the third case, this time brought by Capital One, he begins with his customary special appearance.
Portfolio Recovery Associates versus Marcus Campbell. Your appearances.
Yes, good morning, Honor. Michael Kirshenheider for the plaintiff, P75722.
And what is your name, sir?
Marcus Jamel Campbell in special appearance for.
In special appearance for what, sir? You filed an answer here. All right.
Marcus Jamel.
Let that sink in. Marcus sincerely feels that he should be compensated for defending himself in a debt lawsuit. This is utterly foolish, but oddly audacious. He is not only contesting the legal process, but also trying to change the rules entirely. The judge, who is obviously accustomed to this type of argument, remains calm, acknowledges the unusual claims, and establishes a discovery schedule. Marcus is given one more chance to handle the issue seriously. But considering his prior actions, it feels more like witnessing a predetermined ending play out than a possible turnaround. The court is patient, and Marcus reacts more bewilderedly to the move.
That motion, Mr. Campbell?
I'm not sure if I have, but I'm wondering if you all have my paperwork. I'm not sure if I did.
I have a motion filed by Mr. Campbell. My question is, did Mr. Kirshenheider, did you receive his motion?
I perceive so.
Okay, so you got the motion, the summary disposition filed by the plaintiff. Mr. Kirshenheider, did you hear Did you get the motion filed by the defendant?
Your Honor, I'm not exactly sure what we received. It just says brief and memorandum of law.
Yep. Okay, that's fine. We have that. Now, Mr.
Yes.
Campbell, my question
Yes,
to you is that your answer to the motion for summary disposition?
Yes, it is.
Go ahead to the last hearing. On the most crucial day, the judge doesn't need to spend much time considering the outcome because there is no response or appearance, and the decision is automatic summary disposition granted capital. Marcus was supposed to finally present a real defense on June 13th, but when the virtual courtroom opens, there is no sign of him. Not even a simple message after all the arguments and filings. If Marcus wins, he doesn't merely lose. Instead, he skips class entirely, much like someone who never studies for an exam.
Under your motion, is that what you're both telling me?
Yes, as long as
Okay, here's what we'll do. The court will calendar for May 1st at 11 o'clock, plaintiff's motion for summary disposition. We will receive Mr. Campbell's pleadings denominated brief and memorandum of law and proof of service as the answer to that motion. This is 22-198398, Portfolio Recovery Associates versus Marcus Campbell. Date and time for a motion for summary disposition. Could I have your appearance?
Good morning, Your Honor. Jeff Werber, P67124 on behalf of the plaintiff.
And what is your name, sir?
Marcus Campbell in special appearance.
Mr. Werber.
Yes, Your Honor. Today's the date and time set for plaintiff's motion for summary disposition pursuant to MCR 2.116C9 and C10. This was a Care credit card issued by Synchrony Bank. It was opened up on November 29, 2018. As the invoices attached to the motion reflect, the last payment made on this account was June 30th, 2021. At the time of charge-off, it left a balance of $3,171.94, the exact amount the plaintiff filed the lawsuit for. Those monthly invoices were all mailed to the defendant at his current address, which he placed on his answer and his response to the motion for summary disposition. Defendant made payments on this account for almost 3 years and has not shown that he ever objected to those monthly invoices that he received in the mail. He filed a general denial answer and a lengthy response to plaintiff's motion, but neither provide this court with a genuine issue of material fact or a true defense to this motion. So plaintiff requests that the court grants its motion for summary disposition today.
Mr. Campbell,
Yes.
your response, sir.
I sent a brief regarding the denial.
Yes, the
No.
court had the opportunity to read your brief. And I thought it was an interesting set of matters.
Marcus' absence was the last straw in a case that was already coming to an end. The judge goes over the paperwork and affirms what was clear. There isn't any genuine disagreement, no important facts are in doubt, and there isn't even a legitimate defense. What started off as a standard scheduling meeting ended in a significant legal setback. Marcus is currently at 0 for 3. He is not only losing, but doing so dramatically. If this were a streaming series, the title might be How to Lose Every Case Without Even Trying. It combines courtroom drama, inadvertent comedy, and a significant amount of secondhand embarrassment.
What you want to say in addition to what was filed?
Right. I have not contracted with them, and I do not wish to contract with them now. I just want to make sure that the brief is on the record, though.
I see your brief and memorandum of law and proof of service.
Yeah. So all of that is on the record.
I see it's
That's all I-
filed here, and I see
Yes, sir.
all.
That's all I know.
I know, for example, that you cite federal rules of civil procedure. I know, for example, that you cite 28 USC 2403. I
Mhm.
further note you cite MCR 2.614. Okay, I'm prepared to rule.
Yeah.
Having had an opportunity to read the pleadings both by Mr. Werber and by Mr. Campbell, the court is satisfied that there is no genuine issue of material fact. The motion for summary disposition under MCR 2.116C10 will be granted. I'll send you gentlemen out of order. Did you attach an order, Mr. Werber?
Yes, Your Honor, there is an order attached to plaintiff's motion. It's right before all the exhibits.
I see it. I see it. All right, the
Right.
court will enter that today. Mr. Campbell, you have an absolute right to appeal my decision. That appeal must be perfected within 21 days of today.
It's noteworthy that Marcus truly seems to think he's winning and frequently uses ambiguous legal terminology, federal citations, and internet-based fallacies as if they were sound legal tactics. He could have hired a lawyer, set up a payment plan, or even said less and fared better. But instead, he chose to act as his own legal expert and kept getting outmatched by professionals who truly understood the law. His filings were so disconnected from reality.
913. This is Capital One versus Marcus Campbell. The matter is before the court set for a status and scheduling conference. And I'm looking for Marcus Campbell. If you're on the Zoom, please say something at this time.
Yeah, Marcus Campbell and special appearance.
All right, thank you, Mr. Campbell. All right, today is the date and time set for a scheduling conference regarding this matter. It appears that this is a complaint wherein the plaintiff claims that there is a total amount of $1,874.21 that's owed as a result of a Capital One bank account in this matter. All right, and I received an answer that was filed in this regard, and it appears that the answer is a general denial of any claim of obligation regarding the indebtedness. Counsel, has there been any opportunity for the parties to talk about whether or not this matter could be resolved?
Your Honor, I've not spoken with Mr. Campbell today. Based on some documents that he filed and sent to our office, I don't believe it will be helpful to speak as far as getting it resolved. My office will be filing a motion for summary disposition.
Right. Anything you wish to say at this time, Mr. Campbell, regarding whether or not there is a prospect of resolution in this matter, sir?
No, sir. I just want to be sure that my proof of service, my brief, and my
What can be learned from Marcus Campbell's narrative? Then, you won't win if you take on 3 significant financial organizations with just internet theories and citizen scripts.
That was filed with the court on March the 10th, and that answer sets forth a 23 count response, and then it sets forth affirmative defenses items 1 through 9. That's what the court has received. All right, I am going to set this up on a schedule, allowing the parties to engage in the practice of discovery, that is to request any information that you may need from the opposing party in writing, and that information will be turned over. This process also allows for the submission of interrogatory sets of questions. It allows for requests to admit and other items of discovery that may be allowed under the court rules. Accordingly, I'm going to put this on a 60-day schedule with the return date in this matter set for the 13th of June, 6/13,